My HOA is legally foreclosing on my paid-off $400,000 home over a trash can. Your Honor, corporate property managers are using rigged neighborhood rules to steal houses.
Wait. Stop the clock, Miss Jenkins. Let me check my own hearing here. Did you just say paid off, free and clear? No mortgage, no lenders, completely owned by you?
$0, Your Honor. Not a single penny owed to any bank or lender on earth. My husband and I spent 15 years skipping family vacations, working brutal double shifts, and living on beans and rice just to completely own our piece of the American dream. We sacrificed everything so our kids would have a roof over their heads that no one could ever take away. We thought we were safe. But 2 weeks ago, I came home from work and found a legal eviction and foreclosure notice pinned to my front door. This man's multi-billion-dollar investment firm has placed a super lien on my property and scheduled my house to be sold at a public auction on the courthouse steps tomorrow morning. The total debt they claim I owe them is $3,800. And the original cause of that debt? My teenager brought our plastic trash can inside at 7 p.m. instead of 5 p.m. on a Tuesday evening.
A violation is a violation, Miss Jenkins. The automated billing code does not calculate human intent.
The automated billing code? Are you completely out of your mind, Mr. James? To take a woman's entire life savings because a plastic garbage bin sat on a driveway for 2 extra hours? You better start explaining the math of this courtroom before I lose my temper.
The math is indisputable, Your Honor. The initial fine was $50. Miss Jenkins refused to satisfy it. Consequently, our automated compliance system applied contractually mandated legal costs and administrative fees. The debt escalated. The master deed restriction she signed gives our governing association the explicit right to liquidate the primary asset to satisfy outstanding liabilities. We are simply following the standard operating code.
Following the code? Your Honor, they didn't just follow a code. They bought our neighborhood and reprogrammed it into a corporate hunting ground. They want the viewers at home to think this is just a stupid neighborhood dispute. They want you to think, oh, she should have just paid the $50. But they are deliberately hiding the predatory high-tech infrastructure they deployed to trap us. A few years ago, a massive private equity fund started quietly buying up local neighborhood management operations all across the United States and Canada. They didn't look at us like human beings or neighbors. They looked at us like a captive customer base. They hired third-party compliance fleets to drive through our streets with digital cameras, using automated image recognition software designed to hunt for microscopic infractions. A trash can left out 2 hours past the deadline? $50. A single dandelion on the lawn? $75. Your garage door left open for 45 minutes while you're unloading groceries with a crying toddler? $100. They weaponized the neighborhood rulebook into a digital cash grab. And if you live in a managed community, your house is already inside their radar. Your Honor, today over 70% of all newly constructed single-family homes in this country are automatically locked into a managed association by default. If you look at high-growth states in the South and the West, that number rockets past 75 to 80%. Large corporate developers are making backroom deals with local city municipalities. The cities refuse to approve new housing permits unless the developer forces the neighborhood into a private corporate structure. Why? So the city can collect maximum property taxes, but force the homeowners to pay extra out of pocket to maintain their own roads, streetlights, and drainage. Working families, young couples trying to buy their first starter home, and elderly citizens trying to downsize have zero choice. You literally cannot buy a modern house in a safe school district today without being forced to sign away your property rights to a private investment firm. It is a forced monopoly.
Your Honor, the macro-level availability of non-associated housing has no bearing on contract enforcement. Miss Jenkins signed a restrictive deed covenant when she purchased the asset. Furthermore, she was sent multiple automated notifications via our digital corporate billing portal. If she ignored her smartphone alerts, that is a user-end compliance failure.
Oh, really? Let's talk about your digital billing portal, Mark, because this is where the legal compliance turns into a literal white-collar heist. Your Honor, listen to this closely, because this is how they trap you even if you pay your bills. Most states have consumer protection laws that explicitly say a neighborhood board cannot foreclose on an American citizen's home over simple fines alone. The law says foreclosure can only be triggered by unpaid monthly assessment dues. The corporate lawyers who run this firm know that law perfectly. So their software engineers programmed a hidden compliance loophole into the system called payment reallocation. Every single month, my bank records prove that I paid my regular $100 monthly neighborhood dues on time, down to the exact penny. But the moment their automated camera flagged my son's trash can, their software instantly generated a $50 fine, and the algorithm is hard-coded to apply any incoming homeowner payments to fines and corporate legal fees first. because their corporate algorithm quietly stripped $50 out of my payment to pay off their fake fine. It left a $70 artificial deficit in my actual monthly dues. I had absolutely no idea this was happening because they stopped sending physical paper mail. They hid the line item financial breakdown 6 pages deep inside an online digital app user agreement that updates automatically. Within 90 days, their automated system flagged my account as delinquent on primary assessments. The exact millisecond that digital flag went off, their corporate legal department began tacking on $200 legal notification fees, $100 late administration surcharges, and $300 file processing penalties every single week. They deliberately kept the financial ledger hidden in the dark, letting the fake debt snowball exponentially until it legally crossed the statutory threshold required to trigger a home foreclosure.
Mr. James, look at me. Answer this court directly, and remember you are under oath. Did your corporate entity receive Miss Jenkins' full monthly dues payments on time every single month? Yes or no?
The capital transfers were processed, Your Honor. However, under Section 9 of our Master Digital Terms of Service, all incoming consumer capital is automatically allocated to outstanding ancillary balances chronologically. This is a standard debt prioritization algorithm explicitly engineered to optimize our institutional investors' portfolio yields and mitigate risk.
They don't want the $3,000, Your Honor. That is the ultimate secret of this entire private equity playbook. They don't want the cash. They want the $400,000 asset. Look at this certified state document, Your Honor. This is the official business registry for the specific anonymous shell company that is contractually registered to buy my home at the foreclosure auction tomorrow morning for the exact price of the fake debt. And do you want to guess who actually owns and controls this anonymous shell company, Your Honor? Look at the corporate registration signature at the very bottom. It uses the exact same corporate parent fund, the exact same executive board, and the exact same financial account numbers as this man's property management firm. They use their own automated software to fabricate a fake fine, use payment reallocation to create an artificial default, block the homeowner from seeing the paperwork, force a hidden non-judicial auction, and then use their own shell company to buy a paid-off $400,000 home from a working-class American family for $3,000. It is a predatory vertical white-collar laundering machine.
Objection! This is standard proprietary investment strategy. The corporate layering structure is entirely compliant with current real estate and non-judicial foreclosure statutes. We are legally obligated to maximize value for our shareholders.
Sit down, James. Shareholder value does not override the Constitution of the United States, and it certainly does not override basic property rights in my district. Your investment firm didn't purchase a legitimate real estate management business. You engineered a digital pirate ship to systematically extort regular working citizens who spent their entire lives earning a home. Property law was established to protect honest citizens from theft, not to provide multi-billion-dollar private equity funds a legal license to run a financial hostage situation against families using predatory billing algorithms. And we are not just talking about civil contracts anymore, Mr. James. This court is looking at systemic equity fraud, structural racketeering, and predatory asset laundering. I am personally handing these corporate registry documents directly to the state attorney general and the federal housing authorities for an immediate, sweeping criminal investigation. If my office discovers that your software loop has taken a single home from a senior citizen, a veteran, or a working family in this state, I am not going to issue a corporate fine. I am going to personally sign the arrest warrants to put your entire executive board inside a concrete cell. By the power vested in this court, I hereby issue an immediate, permanent injunction canceling the foreclosure auction of Miss Jenkins' home effective right now. Furthermore, I strike down every single administrative fee, late penalty, and legal surcharge levied by this management firm against every single homeowner across this entire judicial district. This fraudulent debt is completely wiped out. Case dismissed. Please leave my courtroom now.